Hi, everybody. My name is Laurah Jurca. I am an ELD instructional coach in Prince George's County, Maryland. And today I wanted to talk to you a little bit about our multilingual learners and specifically the laws regarding our multilingual learners and their rights as students. So, first of all, I think that it's important that any teacher who has multilingual learners in their class needs to know the laws and the policies and the procedures that relates to these students. Many times these students need somebody to be an advocate for them. And if you know their legal rights to an education, then that gives you the power to advocate for that student from a position of what is legally and ethically right. It's also important that as an educator, we be able to clearly articulate these rights and their implications to our colleagues, to students' parents, and to other stakeholders in the student's education. So let's take a look at some of the court cases and laws that pertain to our multilingual learners. So the first one is Mendez versus the Westminster School District. And this one basically comes down to our multilingual learners cannot be segregated. In the 1930s, nearly 80% of California school districts were segregating Mexican students in separate Mexican schools. And if they tried to enroll in white serving schools, then they were denied. So, five parents whose children attended schools in California in different districts, they filed a class action lawsuit. And in 1946, the federal court ruled in favor of the students, saying that multilingual learners cannot be segregated. A year later, in 1947, the U.S. Court of Appeals for the Ninth Circuit handed down a unanimous decision upholding the original judgment. So multilingual learners cannot be segregated into separate schools. They can be in pull-out ESOL programs. That's not considered segregation, but putting them in completely separate schools or denying them access to programs that American students have access to is illegal. Next, our multilingual learners have a right to instruction in language that is comprehensible to them. This comes from the court case Lau versus Nichols, which was in 1974. In this case, a group of Chinese American parents brought suit against the San Francisco School District, saying that their students were not receiving supplemental English language courses that allowed them to acquire English. As a result of lack of access to English language education, the students were therefore being denied equal access to the curriculum. In this case, the Supreme Court ruled that school districts must take necessary steps to provide multilingual learners with equitable access to the curriculum, including supplemental language courses and language acquisition programs. And that leads us into Castaneda versus Pickard, which says that multilingual learners have a right to high quality language instruction programs. So in 1978, this case argued that a school district in Texas was providing to fail an acceptable bilingual education program in which immigrant children could learn English. In 1981, the U.S. Court of Appeals for the Fifth Circuit stated that a three-pronged test must be used to ensure that bilingual or English language acquisition programs were meeting students' needs and rights. So as a result of this ruling, English language programs are required to be number one, based on sound educational theory, number two, effectively implemented with sufficient resources, and then number three, evaluated and proven to be effective. Plyer versus Doe is a court case that says that even undocumented students have a right to free education. So back in 1975, the Texas state legislature passed a law that would withhold state funds from being used for children who were undocumented immigrants. In many cases, this law was used to bar undocumented students from enrolling altogether. The US Supreme Court ruled in favor of the student, stating that under the Equal Protection Clause of the 14th Amendment, it's unconstitutional to deny any student a free elementary and secondary public education, as long as they are living in the US. And this is regardless of their immigration status or their parents' immigration status. And then finally, and this one is big, this came out from the 1983 Office of Civil Rights, and they stated that it's their policy to find a violation of the Civil Rights Act of 1964 if multilingual learner students are retained in grade for failure to demonstrate basic skills in English. So it's illegal to retain students based on lack of English proficiency. They must be given modifications and accommodations to make the curriculum accessible to them. And if they are not provided with such accommodations and modifications, number one, that's illegal. And number two, they cannot then be retained in grade level. So I hope you found this review of laws regarding our multilingual learner students helpful. And I hope that it equips you with some information to help you advocate in favor of your multilingual learners this school year. Thank you.